Congo, the principal judge, the High Court of Kenya.
Establishing the International Crimes Division, or ICD, has been a highly sensitive process, both politically and legally.
So we were wondering, if we make it part of the International Crimes Division, how will we structure the courts?
Initially, I was opposed outrightly to that. I have since reconsidered this, and I have an open mind, and I'm willing to be persuaded that it is viable and necessary.
From today, what we are going to embark on is the actual setting up of the ICD.
The ICD is expected to enhance the domestic capacity to address international crimes and to deter serious crimes. The State Law Office has been under intense pressure to demonstrate to the international community that Kenya is willing and able to try international crimes, such as those that happened during the post-election violence of 2007 and 2008. Even then, however, all the perpetrators accused of various crimes following the violence may just go scot-free if the report of the task force appointed by the Director of Public Prosecutions to review all the 5,000 files arising from the violence is anything to go by.
Of the 4,000 plus files that they have reviewed, none of them is prosecutable. None of them. And that is the fact, the sad and painful fact.
The most candid statement ever from government about the status of the pending post-election violence cases.
None of them has been found to contain sufficient evidence to be prosecuted, whether as international crimes or otherwise. What am I saying, therefore? I'm saying this. The sad and painful truth, and we must face it, is that at present there are no cases arising out of the PEV that can be prosecuted before the ICD.
We have given our citizens a false hope arising out of the 2007-2008 conflict that we are going to ensure that the crimes against humanity which were committed, and which I say in quote, will be tried.
Perhaps then the ICD can only focus on future crimes with regards to international crimes. The whole question of the jurisdiction of the ICD is a dicey one, considering that even the transnational crimes such as terrorism, piracy, human and drug trafficking it's expected to handle have and continue to be handled by the existing courts.
And you think that just calling for those files will just be happily handed over? You will invite enormous, huge constitutional litigation.
There are also concerns that the special division could be overwhelmed by the number of cases that will be brought before it.
As you know, the High Court is already challenged. We, this year alone, have set up 5 benches, 3 of 3 judges and 2 of 5 judges. So you can imagine if each of those cases in each of those benches takes on average 3 or 4 days to complete, it means that we have lost 18 judges for 4 days. That's quite a number of man-hours.
The committee working on the establishment of the ICD has visited several countries with similar courts, including Cambodia, Sierra Leone, Bosnia, among others, to inform the determination of a favorable model for Kenya.
A consensus with the JSE that the Bosnian model might be the most appropriate to base Kenya's International Crimes Division of the High Court.
It is also proposed that an elite unit of prosecutors and investigators independent of the office of the DPP will handle cases before the ICD.
That proposal is a misnomer, at best. At worst, it is a constitutional fallacy.
Sylvia Chebet, Citizen Live at 9.